story about how a poorly made and very bigoted movie taught us about copyright law. It begins with an actress who responded to a casting call for what she was told was a movie called Desert Warrior, and she said a couple of lines. A few months later, a video was uploaded to YouTube called Innocence of Muslims, and you might remember it. It sparked riots and fury and death threats to the actress. The actress's lines weren't even used. They used her face and they dubbed some other lines over it to make it sound more hateful and bigoted, and it was very problematic for her, and she tried to get YouTube to take it down, but YouTube would not, claiming that she did not have a copyright interest in it. So she sued for copyright infringement. She claimed that as an actor in the movie that she had an authorship interest. And briefly, the Ninth Circuit Court of Appeals, a three-judge panel, agreed that she had a likelihood of success on the merits and ordered Google to take it down. So Google sought what's called an en banc hearing, where more judges hear the case, and they thought about it very differently, and they ruled against her on the copyright issue. Now, I think there's a very real copyright issue here, which is whether or not an actor in a movie can claim a copyright interest, an authorship interest in the film, but her claim was particularly weak in the wrong test case for it. Number one, her role was way too small. She had a couple of lines and they didn't even use her lines. They just used her face and expression. Number two, the filmmaker was out of the picture. He disappeared. He was in jail for other reasons and he didn't respond. So it was really Google's fight, who doesn't really care that much about authorship issues. Number three, the harms that she was claiming wasn't really a copyright harm. She wasn't trying to exploit her copyright or make money off of it. She just wanted the video taken down because of death threats and because it was a very ugly film, which is reasonable, but it's not a copyright harm, which leads me to the fourth problem. She was seeking a preliminary injunction. She was seeking in an order before the litigation was over that YouTube take down every single uploaded version of that video, and that implicates First Amendment interests. So the Ninth Circuit Court of Appeals held against her. They held that someone with a small role like that shouldn't be deemed an author of the film because otherwise there can be dozens or countless different people associated with that movie who can claim an authorship interest and hold the thing up. And filmmakers aren't necessarily going to get releases from everybody who made a contribution to the film. So it's really that terrible person who made the film is the author and not her, and she cannot enforce a copyright interest. That would have been good enough, but the Ninth Circuit went farther and held that she couldn't be an author because she wasn't the one who fixed the work. And I think that's a problematic holding. I don't think that's a correct version of copyright law. Fixation and creation are different. When a choreographer creates a work, sometimes someone else does a video of the work so that it can be registered with the Copyright Office. It's not the person who did the video that has the copyright interest. It's the author, the choreographer who did. So I don't think the Ninth Circuit had to go that far. And by going that far, I think they shut down the question of an actor's interest in a motion picture, basically shutting down the idea that an actor, by acting in a film, no matter how great their contribution can be, can ever be an author of a film.